Um, here we go. Once again, 6050601, power to dissociate a member with a wrongful dissociation. A person has the power to dissociate a member at any time wrongfully withdraw as a person that expresses the will under the person of dissociation wrongful. Only the dissociation is in breach and expresses the provision of the operational agreement that occurs before the completion of the winding up of the company, and the personal withdrawals of the member that is expressed with will. The person expelled is a member of judicial order. Person dissociated under 6050602. If an individual case is not a trust under the business trust, and in the state of the individual person expelled, otherwise dissociated, the member will be willfully dissolved or terminated. A person with wrongfully dissociated member is liable under the Limited Liability Company Act. Company is subject to the statute 6050801. Other members of damages caused by the dissociation liability of additional in each debt or organization, debt or obligation, other liability of a member of the company, other members, notwithstanding any of the contrary under applicable laws or articles or organization or operation, a meeting of the providing limited liability company interest may be assigned before the dissolution winding up of the limited liability company. 605-602, event of the cost of dissociation. A person dissociated is a member if in any of the following occur. The company has not notice of the person expressible but the withdrawal as a member if the person withdraw the date later than the date of the company has notice of them later than the date. An event is started with the operating agreement causing the person dissociating occurs. A person enters the entire interest transfer, the foreclosure sale under. This person expelled with the member pursuant to the operation agreement. The person expelled as a member anonymous consent of the other members is if any of the following occur. If it's unlawful to carry the company activities affairs of the person as a member, there may be transferred the person entire or transferable interest of the company other than transferable security purposes, charging order of the effect of under section 6050503, which has not been foreclosed. The person is a corporation and the company notifies the person that it will be expelled as a member because the person is field article certificate of dissolution equivalent to the person may be administratively dissolved in the charter. The equivalent has been revoked. The person right to be conducted business and be suspended by the person jurisdiction in the formation. Within 90 days of the notification, articles of certificate of dissolution of the equivalent has not been revoked in the charter. The right to become conduct business has been reinstated. A, the person is unincorporated in any of the dissolved whose business is being wound up. B, or that was D. 6, one application of the company's member to the direct direct action under 6050801. The person expelled is a member of the judicial order with the person has engaged in engaging wrongful conduct that affected the adversely material will affect adversely material. The company affects activities affairs the committed with willfully persistently committing with the willful persistent material breach of the operating arrangement duty and their obligation under the 6050491. Has engaged in conducting relating to the company's activities affairs, making it responsible practicable for the carrying out the activities and affairs with the person as a member. In case of the individual dies, the member of the management limited liability company 1, a guardian general conservator for the individual is appointed. The judicial order of the individual other than incapable of performing individual duties of the members under the chapter of the operating arrangement. 8. In a member managed by a limited liability company, the person A becomes a debtor and the bankruptcy. B executes assignment for the benefit of creditors. Seeks constant acquisition and the appointment of the trustee, receiver, liquidator, and the person that all for substantial all personal property. 9. In the case of the person in the testimonial interversios truster is acting as a member as virtue being trustee as in such trustee the trust entries the transferable interest in the company is distributed. 10. In the case of the person in the estates is acting as a member by the virtue of being legally represented as states the entire the transferable interest in the company is distributed. 11. In case of the person is not involved, the existence of the person terminates. The company participates in the merger of statute 605-1001, 605-1026. The company is not surviving entity. Be otherwise resolved. The merger of the person ceases to be a member. 13. The company participates in so interest that under the 605-1003. 1031 1000 through 1036, the person ceases to be a member. The company participates in the conservation of 605-010 1041 to 6051046. The person ceases to be a member. The company dissolves and completes winding up. 6050603, effective dissociation. If the person dissociated with the member, the person in participates in the member of the debt, conducting the company's activities and affairs that terminate. The company is member the manager and duties of the obligation of 605040191 as a member regarding matters arising and even occurring after the person's dissociation. The subsection subject 6050504 6050101 1001 transferable interest owned by the person in the person capacity immediately with dissociation of members owned and personnel solely and transfer. Person's dissociation as a member does not in itself and discharge the person in debt and the obligation of liability of the company, other members, and the other person and incurred while a member. 6050701 event causing dissolution. The limited liability company is involved in the activities and affairs is wound up with the occurrence of the following event and the circumstances of the operating arrangement statement causes dissociation with the consent of all members of the passage of a 90 consecutive day during the company has no members unless consent admitted at least one specified member person the member is given the transferring owning the rights to receive majority of the distribution transferability of the term of the consent to be effective. B, at least one person becomes a member in accordance with the consent. 4, the entry of the decree of the judicial dissolution is in accordance with the statute 6050705. Filing a statement of the administrative dissolution of the department pursuant to section 6050714. 6050772 grounds of judicial dissolution. A circuit court may dissolve a limited liability company A in proceeding of the Department of Legal Affairs as established. 1. The limited liability company obtained with the articles of organization was through fraud. The limited liability company has continued to exceed and abuse authority conferred upon its law. The enumeration subparagraph 1 and 2 grounds of involuntary dissolution does not exclude actions, special proceedings, Department of Legal Affairs, state officials, and an element of dissolution, limited liability company, other causes that provided in another law and of the states. B is proceeding a member if and establish that 1 of the conduct substantially all the company activities and affairs is unlawful, is not reasonable to participate. Grounds for judicial dissolution. It is not reasonable to participate and carry out the company activities affairs in conformity with the Articles of Organization Operation Agreement. The managers or members in control of the company have acted or acting or are responsibly expected to act in the manner of the illegal fraudulent. 4. The limited liability company assets the misappropriated waste causing injury to the limited liability company and proceeding by the company causing injury to one or more of the members and managers and members of the limited liability company deadlock of the management of the limited liability company activities affairs and for the members unable to break the deadlock and the irreparable injury limited liability company is threatened and being suffered. In a proceeding of the limited liability company have voluntary dissolution continued under the court's supervision. 2. If the manager of the members of the limited liability company are deadlocked in the management and limited liability company activities of the affairs, the members of the are unable to break the deadlock and irreparable injury to the limited liability company is threatened or being suffered the operating arrangement contained with the deadlock safe provision that has been initiated before the time that determines the grounds for judicial dissolution exists for the subparagraph 1b 5. The such deadlock sales provisions apply for the resolution of such deadlock instead of the could enter the judicial dissolution and order directing the purchase petitioner's interest of 6050706. As long as provision of deadlock safe provision therefore initiated effectuated in accordance with the terms of such deadlock safe provisions otherwise pursuant to the agreement members of the company as used in section the term of the deadlock safe provisions means the provision of operating arrangement which may be applicable in the event of the deadlock made among the managers members of the limited liability company which members of the company are unable to break, which provides the deadlock of the breaking mechanism including not limited to a purchase or sales of an interest of the governance chains by bone between the members for the sale of substitutionally all assets of the company. A similar provision initiated and effectuated breaks the deadlock by causing the transfer of the interest, governance change, and sale of substantially all the company's assets. A deadlock sale provisions in an operating arrangement which should be initiated effectuated before the court enters the judicial dissolution under subparagraph 1B5 in order to be directing the purchase petitioner's interest of 605-0706 does not adversely affect the right of the members of the managers to seek judicial dissolution under subparagraph 1B5. The rights of the company and more members to the purchase of the petitioner's interest of 605-0706 filling the action's judicial grounds described in subparagraph 1B5 of the election to purchase the petitioner's interest of 605-0706 does not adversely affect the right of the member to initiate available deadlock sale provisions under the operating agreement to enforce member initiated automatically initiated deadlock sale provisions if deadlock provisions initiated and effectuated before the court enters an order of judicial dissolution under subparagraph 1B5 and other direction of purchase of petitions and interest under 605-706. 605-0703 procedure for judicial dissolution alternative remedies. Revenue proceeding brought by under 06702 Lewis of the Circuit Court of the country where limited liability company principal office is, which last located is shown in the record of the department. If there was no principal office in the circuit of the court, the county where the company registered office is last located. It is not necessary to make the members and parties of the proceeding to dissolve limited liability company unless relief is sought against the members individual. A court proceeding brought to dissolve limited liability company issuing injunctions appointed the receiver, the custodian, pendant light with all powers and the duties of the court and taking action required to preserve limited liability companies as whether located to carry out the business of limited liability company until the full hearing can be held. And proceeding under the section 605-0702, the court, upon showing a sufficient merit, was warranted such a remedy. A. Appointment of the receiver, the custodian under. B. Order the purchase pertaining to the members' interests of pursuant. C. Upon showing the good cause, order the remedy of the court deems appropriate for the direction of including the equitable remedy. Sections 570105 applies to proceeding brought to 605-0702. 605-0704 receivership and custodianship. A court in the judicial proceeding brought to dissolve limited liability company may appoint one or more of the receivers to wind up the liquidated, one or more of the custodians to manage the business affairs limited to liability courts. The court shall be hearing after the notifying all the parties of the proceeding interested designated by the courts before appointing the receiver, custodian, the court appointing the receiver and custodian have all exclusive jurisdiction on other limited liability company of all its properties where they're located. 2. The court may appoint the person authorized to act as a receiver, custodian. The court may require the receiver, the custodian, to post bond without sureties. The amount of the court directs. The court will describe the powers, duties, and the receiver of the custodianship and appoint with the order, which may be amended among the other powers. A. The receiver may dispose of all the parts of the assets limited liability company whether they're located at public or private sales if authorized by the court. 2. May sue or defend the receiver's own name, the receiver's limited liability company in all courts of the state. The custodian may exercise all the powers of the limited liability company through in place of the manager's members that may extend the manage the activities and affairs of the limited liability company to be in the interest of the members and creditors. 4. During the receivership, the court redesignated the receiver as a custodian. During custodianship, may redesignate custodian as a receiver if in doing so in best interest of the limited liability company as the members of creditors. During the receiver and the custodianship may be compensated and paying expenses. Distribution reimbursements may be a receiver, custodian, counsel from the assets, limited liability company proceeding the sale of the part of or all of those assets. 6. The court of the jurisdiction appointed the ancillary receiver for the assets business of limited liability company. The ancillary receiver shall ancillary to receiver located in another state. The court deems the circumstance exists requires appointment such as a receiver. The court appointed the receiver of the foreign limited liability company, even though the receiver has not been appointed such elsewhere. The receiver shall be converted into an auxiliary receiver and in order to enter by the court of the competent jurisdiction in other states provided with the receivership of the foreign limited liability company.